first case is State of Ohio versus Matthew Grose. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments. Please refer to them by initials or terms like the child. We have read your briefs and are ready to proceed in your honor.
Thank you, Your Honor. Attorney John Kopisakis on behalf of the appellant, I'd like to reserve 5 minutes for rebuttal, Your Honors. Your Honors, as I'm sure you've read in my brief, these are pretty straightforward arguments. The primary argument is that the court failed to properly advise the appellant of his right to a jury trial at any point during the proceedings, but especially during the arraignment. Criminal Rule 5 is pretty clear in that the court has the duty to, the court shall advise the defendant of his right to a jury trial, and where it is appropriate in petty offenses, advise him of the need to make a demand as such. There was no advisement in that effect to the defendant. The case law is pretty clear that the defendant needs to bring that up, that defect to the court in order to preserve that argument for appeal and for it to be cured by the court. Mr. Grose made that pretty clear to the court on his second hearing that he had not been advised of his constitutional right to a jury trial. Instead of properly advising Mr. Grose of his right to a jury trial, the court began a long, arduous process of arguing with the defendant in regards to whether or not he was going to have a retained counsel or assigned counsel. The court never actually gave him his advice that he had a right to.
Had he waived his right to a jury trial before that hearing, or that after?
No, he did not waive his right to a jury trial, but he did file a motion for later on.
For a bench trial.
For a bench trial.
Was that filed before or after that hearing?
That was filed after that hearing. Forgive me, I don't have the exact timeline memorized, but I believe it was.
We'll check to see, but I just asked you. Your recollection is that was after that hearing?
It was after that hearing, yes, Your Honor.
That's fine.
But he was never formally advised of his right to a jury trial by the court.
When I was a municipal judge, we played a video with the defendant's rights, and my understanding is there was a video played here. Is that right?
I'm sorry, Your Honor, my hearing is atrocious.
The allegation is that there was a video with the rights that the defendant viewed before being arraigned.
I'm not made aware of that video. I did ask for an entire and complete record from the court of all the court proceedings. The record I provided to a transcriber. The transcriber transcribed that into the record, and we filed that record with this court.
So there was nothing in the transcript that said video was played, or
nothing that I saw.
Did the judge reference a video? Like, did you understand the rights I read in this video? Or the
No, there
rights
was no reference to that effect. The case was called. He was brought before the judge. The charges were read, and before the judge could discuss a jury trial or the right to a jury trial, the judge got into a confrontation with Mr. Grose because Mr. Grose did not believe the charges that were being levied against him.
Do you think it matters that he had an attorney ultimately?
I believe the case law states that the court is not absolved of that duty, even if he does have an attorney present.
What about also the fact that in municipal court you have to assert your right to have a jury trial, which it sounds like he did,
I believe
and then waived it?
Akron v. Bernato states that because it is the duty of the court to make sure that the defendant is aware of his right to a jury trial, the court cannot assume that his attorney would give him that advice. So in Bernato, there is an individual who doesn't speak well English, and the court does not properly advise him of his right to a jury trial. This court found that we cannot expect that his attorney is going to give him that advisement, and it is the duty of the court ultimately to give him that advisement.
The court can also give a curative instruction, but if someone says, I don't want to have my jury trial, I want to have a bench trial, is it necessary to have the curative instruction in that instance as cured here?
The court can give a curative instruction, and the case law suggests that they should give him a curative instruction. instruction. Curative instruction was never given in this situation. Even so, because the curative instruction was never given, the duty is still on the court to give that advice to counsel, or to give that advice to a jury trial. Even if he says, I want a bench trial, it must be assumed that he was never advised of his right to jury trial.
Let me take a step back on the question Judge Lansker asked. The appellee said there is a video that's played. Do you dispute that one way or the other, or you just don't know it wasn't in the record, so you can't say?
I don't see any reason why we would assume that it was played. There's nothing in the record suggesting that it was played outside of the assertion of the appellees. There's no reference of it in the record, and furthermore, it's such a important right, and the duty is on the court to make sure that the defendant knows of this right, that the simple, you have a right to a jury trial would have served that right, and the court refused repeatedly.
Well, I believe the court has said that other courts in the past have said that yes, you can play those videotapes and have that right to explain that way rather than individually each person you call up. I believe there's a case law that does permit that. But in your view, you cannot say in this case whether it wasn't played. Is that what you're saying?
Yeah, I can't find anything in the record that suggests that it was or wasn't played. Nobody's made reference to it one way or another, outside of the appellees asserting that it was played, but there's nowhere in there that suggests that it was. It would be no different than assuming everyone understands their Miranda rights because we've all seen the Miranda warning on TV.
Well, that's different. I mean, we're not saying, hey, did you watch Castle one day so you understand Miranda rights? We're saying, is there a video that was played that the court prepared and showed before every hearing? That's a little bit different than saying, well, people should understand Miranda rights. You know, it was or wasn't played. Now, again, I appreciate nothing in the record says it was played, so it's not part of the record today. I understand that part of it. And that's your position, ultimately, it's not in the record.
It's not in the record, there's nothing there. Then the second argument we make, Your Honor, is that the court imposed an illegal sanction with a no contact order. There's pretty clear case law stating that once the court has given the maximum jail sanction and not suspended any of it, the court can't impose community control sanctions afterwards. City of Cleveland v. Bolger.
Well, Bolger was a little different. Bolger, the person, as I read it, because there was a mistake in jail time credit, had actually served 71 days of a 60-day sentence, so their credit with time was served. Their sentence was served, and the court said, well, once you serve a sentence, you can't impose time after that, and then impose sanctions once they're done serving whatever they're supposed to serve. That's a little bit different than what you're saying happened here, because this was before the sentence was served. He was sentenced to a probationary, what you call a community controlled or probationary term, so it's a little bit different. I'm not saying it's a distinction that matters, but it is a little bit different than Bolger.
I would concede that, Your Honor. But in all the same, again, he's been given the maximum sanction. There was nothing further community control sanction.
So if the judge in this case had said, I'm going to sentence him to 179 days, suspend 1 day, and have a no contact order, you would say, okay, under the statute, that would be permissible?
Yes. Any other questions? Thank you.
Good morning. I woke up with a really scratchy throat, so I may have to pause and have a drink of water. I apologize. May it please the court, my name is Michelle Nedwick, and I'm a prosecutor with the City of Elyria, and I'm representing the appellee state of Ohio in this matter today. I was listening to the appellant and the questions you were asking him, and before I get into my big spiel, I will talk about that video. Now, Mr. Grose was arraigned through video at the jail, and so I talked to the bailiffs at the jail, and they say they have this video, and it was prepared. All the jurisdictions see the same video in the jail, and it runs on a continual loop.
And before you get too far on that, have you attempted to supplement the record with that video so that part of the appellate record?
I have not, because it was not part of the record. The trial judge did not ask Mr. Grose if he had seen the video, and so I could not establish that Mr. Grose had seen the video.
So you would concede that that's not part of the record before?
I do concede that. So Going to the appellant's first assignment of error, the defendant, Matthew Grose, argues that the trial court failed to comply with Criminal Rule 5 by failing to advise him of his right to a trial by jury and his right to remain silent. I'm going to first address the issue of the right to a jury trial. The appellant argues that any failure to comply with Criminal Rule 5 will render the entirety of the proceedings invalid. He would have us see this as a black and white rule, regardless of whether or not the error affected the outcome of the proceedings. That is simply not the case. The 4th District in State v. Wilson at paragraph 13 states, a failure to comply with Criminal Rule 5 may constitute prejudicial error. It does not say must constitute prejudicial error. The state asserts that even if the trial court failed to comply with Criminal Rule 5, it did not affect Mr. Grose's substantial rights. Specifically, it did not affect the outcome of the proceedings because Grose was fully aware of his right to a trial by jury and purposely chose a bench trial.
Was it clear he knew he had a right to a jury trial, specifically under the Constitution? I mean, yes, he filed a motion for a bench trial and said, I'd like to withdraw my request, but did he understand that was a constitutional right that he was giving up?
Well, he did indeed know he had a right to a jury trial. And in that motion that he filed, which is attached to...
We knew he made a request. I mean, did he know, is there anything that tells us he knew the court could have said, no, I don't want to give you a jury trial, too bad?
No, there's nothing in the record.
There's nothing on the record that they ever explained to him his constitutional right to a jury trial.
That's correct.
But you would view this motion that he filed as meaning he wasn't prejudiced by that lack of explanation. He could have had one and just chose not to.
Correct. And a little bit later in my argument, you know, he requested a bench trial, he requested to withdraw his jury demand, and then he said, he set forth his reasoning. He chose a bench trial because he thought it would be the quickest way, you know, to bring justice. So to me, that means he weighed the pros and cons of whether to have a jury trial or a bench trial, and ultimately chose a bench trial.
Are any of the cases that you've seen, Wilson, Baratano, all these cases that deal with it, do any of them have any kind of an actual waiver by the defendant or anything like that of their jury trial?
I mean, anything like this motion?
Anything like this motion, right?
Yeah, I have not seen any.
One way or the other.
Right. I know in the Baratano case, that defendant, he entered into a plea agreement without anything on the record indicating that he was ever advised of his jury trial or that he was aware of his right to a jury trial.
And I don't recall in Baratano, was the record not clear? Because typically someone enters a plea, they sign a plea agreement, or there's some kind of questioning of them during that time to determine whether or not, do you understand you have a right to a jury trial, you're giving that up by going to trial. There's nothing in that case that indicated that occurred at all.
Right, and plus he didn't, English was not his first language, and they did not provide an interpreter. So they couldn't even establish that Mr. Baratano understood the proceedings. So again, the state asserts that even if the trial court failed to comply with Criminal Rule 5, it didn't affect his substantial rights, and it did not affect the outcome of the proceedings. He chose a bench trial, and that is what he received. Therefore, the outcome of the proceeding was not affected, and substantial rights were not violated. And then again, I'm talking about that case, City of Akron versus Baratano. They recognize that the right of trial by jury is a substantial right. And they cite the Ohio Supreme Court in State v. Perry that under Criminal Rule 52, the government bears, excuse me, bears the burden of demonstrating that the error did not affect the substantial rights of the defendant. And as we talked about, the court in Baratano was ultimately not, the government was not able to demonstrate that it did not affect his substantial rights. I believe that.
Are we talking apples and oranges though when we're talking about plea colloquies versus the person went to trial?
Yes, I mean, it is apples and oranges, but it's also, they both had a right to a jury trial. Mr. Baratano chose a plea agreement. Mr. Grose weighed his options and chose a bench trial. I think the ultimate issue of whether or not Criminal Rule 5 was complied with is the same in both cases. And also in Baronato, like I said, they could not establish that it did not affect the rights of Baronato. In this case, it is clear by the motion that Mr. Grose filed that he was fully aware of his right to a trial by jury. And like I said, he even indicated his reasoning why. So it is the state's assertion that the trial court's error, if there was an error, did not affect the substantial rights of Mr. Grose, as it did not affect the outcome of the proceeding.
What about not just the jury trial, but the statements? They also say that he would not advise that he did not have to make any statements, and any statement can be used against him.
I am definitely getting to that one. I did want to note, and I did not know Justice Carr was going to be on this panel, but I'm quoting you from your concurring opinion in Baronato, which stated, to establish plain error, one must show that an error occurred, i.e. a deviation from a legal rule, that the error is plain, that there is an obvious defect in the proceedings, and that the error affected a substantial right, i.e. affected the outcome of the proceedings. Notice of plain error is to be taken with the utmost caution under exceptional circumstances and only to prevent a manifest miscarriage of justice. In the case of Barr, the state asserts that the trial court did not violate Criminal Rule 5 because he was shown a video of his rights in the jail. But understanding that I cannot establish that and it is not part of the record, that being said, even if the trial court did fail to comply with Criminal Rule 5, with regard to Grose being advised of his right to a trial by jury, their error did not affect his substantial rights and did not affect the outcome of the proceeding, and no miscarriage of justice occurred. Now you were asking me about the right to remain silent. Criminal Rule 5
I still
provides...
have one more question, I'm sorry, on that
Okay.
subject. And muni courts and misdemeanors are special because you don't, with felonies, you automatically have the right to a jury trial. It gets set for a jury trial, you have to in person waive your right to a jury and in writing. With muni court, you have to demand a jury trial or it gets set for a bench trial. So in this case, he demanded a jury trial. So then when he waived his right to a jury trial, did he do so in writing and on the record with the judge? Is that required with a misdemeanor?
It was...
Once you demand a jury?
It was in writing, and that motion is attached to my brief as Appendix A. I don't know if it was done on the record.
You don't know if there's a colloquy?
I don't know.
And you raised the issue of plain error. Did defendant at some point file some motion or objection saying he was not given his proper arraignment under Criminal Rule 5A and ask for the matter to be dismissed?
I believe he did. I think he filed that on his own accord, not through an attorney.
Could
That was
this-
my understanding.
I mean, in this case, couldn't this be some sort of invited error as well?
Yes.
I mean, we have somebody who obviously knows that they have the right to a jury to be able to make the demand in a timely manner according to the rules.
Yes, I believe that it could be an inviting error. Back to the remaining silent. Criminal Rule 5.
Let me go back very quickly to
Okay.
one last question. At the trial in this case, was anything he said in any of these proceedings used against him?
No, I don't believe so. I was not the prosecutor who tried the case though.
But from reviewing the record, you don't believe that anything he said during these hearings was used against him?
I don't believe so. Criminal Rule 5 provides that the defendant need make no statement and any statement may be used against the defendant. Criminal Rule 5 does not say you have the right to remain silent. That's a Miranda warning. It does require that a defendant be advised that he need not make a statement and that any statement could be used against him. In this case, the trial judge clearly advised the defendant of this right. The trial judge stated, it can be used against you, and you're going to get a private attorney, and a private attorney is going to tell you to not to make any kind of statements that could incriminate you. And that's part of the transcript at page 10 through 11. And the state asserts that that language complies with Criminal Rule 5A3. And then lastly, we'll talk about the alleged illegal sanction imposed by the trial court. The defendant was sentenced to 180 days on the domestic violence charge and 45 days on each resisting arrest and obstructing official business, each to run consecutively. And that sentencing order is attached to Appley's brief as Appendix B. Grose was not sentenced to the maximum possible prison term because resisting arrest and obstructing official business have a maximum of 90 days each. That leaves an additional 90 days available, and the trial judge has discretion in sentencing. But more importantly, this no contact was a post-conviction no contact, also known as a 10G. It is considered a court order, and if violated, can constitute contempt of court, which has up to 30 days in jail for a first offense, up to 60 days in jail for a second offense, and up to 90 days in jail for a third or more offense. In addition, contempt can require a fine amount. So even if Mr. Grose had served out the maximum sentence, he still was bound by that court order to not have contact with the victim and could have been punished by a contempt of court action.
Counsel, how is this different than Anderson?
I have to apologize, I'm not aware of Anderson.
Okay, no, that's okay. The reason why I mention is because unfortunately it was my case that went to the Supreme Court, and they told me I was wrong because I was trying to protect victims with a no contact order. So they said if you have a full sentence and you can't do a no contact, you can't have a sentence and community control at the same time.
It's my understanding, and believe me, I researched this and I couldn't find anything solid, unless you talk about Google AI. But my understanding is a regular no contact order, like we used to do, just as part of the sentence. You had to have some suspended jail, or possibly suspended community service or suspended fine. But with the post-conviction no contact, I found that it's considered a court order and can be violated and subject to contempt.
So you're not saying this is a community control sanction against the defendant in this case, rather this is a order, not a community control sanction, not a probationary term, it's just a specific order that's made in this case.
Correct.
Subject to penalty by contempt and not any imposition of jail time.
Yes, if there had been suspended jail, I think it could have been a penalty of both. But I believe in and of itself, it's a court order and could be violated.
So judges can just make random court orders about penalty type of things after they've sentenced someone?
No, I think this one is specific.
I appreciate you say the 10G form and everything else. Is there a specific statute that you'd be referring to regarding this? Your brief doesn't have that included, so other than the 2925. So there's some statute that tells that I was also trying to find some
I was
authority
trying
for
to
that
find it as well.
and confused by our statutes.
Yeah.
I'm not saying misdemeanor sentencing is as well developed as felony sentencing as far as the statutes go, so.
Correct.
But your position is this is not a community control sanction, so we should not review it as a community control sanction.
Correct. And in conclusion, I would assert that Mr. Grose had counsel through this proceeding. He was tried by an impartial adjudicator. He clearly knew his rights. It's the state's opinion that he is trying to escape his convictions on a technicality. The state therefore urges this honorable court to affirm his convictions.
You'll have your full 5 minutes on rebuttal.
Thank you, Your Honor. Your Honor, I wanted to get to the invited error, a review of Bernardo and the case law around expressing your desire to have your Criminal Rule 5 rights complied with demands that the individual bring that up. If Mr. Grose did not make the motion to the court, case law dictates that this would be assumed to have been waived and there'd be nothing to be had then. So he's either damned if he does, damned if he doesn't. He brought it up pursuant to the case law in Bernardo, and he made that motion, he followed through with that motion, and this court, the municipal court did not proceed to cure as has been laid out in the casework.
And I don't recall from the record, when that objection or motion was made, was there a specific written order from the Muni Court in this case explaining why they were denying it?
No, they went on the record, the court said they received it, and then they just kind of moved on to the next phase of his.
Would that have been the hearing that he was represented at that point? I know that there's the initial arraignment, the hearing he wasn't represented, and the third hearing where he was not, then I believe the third hearing where he was represented. Would that have been the hearing where he was represented at? Would that have been, to the extent, at any time it would have been addressed, that's when it would have been addressed?
I believe the second hearing where he was not represented, they did not address the motion directly. They said, okay, we'll hear your motion, and then they proceeded to move forward with the proceedings, assigning him counsel, addressing bond, moving forward from that end. I believe the hearing where he was represented by counsel, again, I don't believe the motion was addressed directly, and then there was the bench trial directly where they just moved forward with the bench trial. I think they denied the motions to dismiss because Criminal Rule 5 was not complied with, and they proceeded with the bench trial, if my memory serves me.
Is your recollection the same question I asked opposing counsel? Baronato and Wilson, all these cases don't have something like this where there seems to be some, I don't know what you would call it a waiver necessarily, but some motion to say I'd like to have a bench trial rather than a jury trial. Do you see any of these cases where there was some filing or acknowledgement by the defendant that he could have a jury if he wished to and chose not to?
I believe you're talking about him filing the motion for a bench trial.
Right, the filing he made saying I want a bench trial, I don't want a jury trial.
I don't believe there was a motion in that regard. I don't think there was anything in that regard at all. But more to the point, the way the case law is written up is to assert that this is, shall mean shall. The court shall tell the defendant that he has a right to a jury trial. The court shall advise him of these things.
Well, we're not dismissing every case because that wasn't done. We don't, in every case that's brought up, they're not dismissed. One, you have to object, number one. You don't object, as you said before, it's not going to be waived. And there may be some other opportunity for curative instructions if courts have said or other type of thing. So in every case, we don't dismiss when that wasn't done. So there's some, yes, it should be done in Rule 5. Does that mean dismissal in every case? No, certainly in Baratano and Wilson, it said, yes, dismissal appropriate because these are important rights people should know about. But where is that? How can it be corrected is the question I think in these cases that we struggle with and deal with.
And Your Honor, I mean, it's a simple thing that we're asking the court to do, which is tell the defendant you have a right to a jury trial. And in petty cases, you have to file a demand for the jury trial, otherwise it'll be assumed that you have a bench trial. It's literally less than 5 minutes to say that simple line, and the court did not say that simple line. It's not a tall ask.
But if you're talking about prejudicial error, wouldn't you have a better case if you never demanded a jury trial to begin with, and then just went to his court date, was set for a bench trial, and said, hey, I didn't know I had a jury trial right. Can I get a jury trial?
This court has found that if it's not brought up with enough ample time for the court to correct or cure, then it's waived. So if he waited until the day of his bench trial and then brought it up at his bench trial, the court would say, well, that error was waived, he didn't bring it up earlier. So.
Well, then he would say that if he truly wasn't informed of the jury trial, then he would say it was prejudicial error that he didn't know he could demand a jury. I mean, in this case, he demanded a jury pursuant to the rule and then waived the right to have a jury trial.
I don't know if he demanded the jury trial. I think he filed a motion for a bench trial to be had. So I don't think there was a jury demand filed.
There was never a jury demand filed, you're saying?
I don't believe so. And I think that might be directly the issue here, is that he was never advised of his right to a jury trial.
And let me ask you, and I appreciate it wasn't raised in the brief or anything else before, on your second assignment of error, this idea that this is an order, it's not a community control sanction, and that's somehow different under misdemeanor sentencing. What would you say about that? And to be fair, it wasn't argued before, so if you say, I know it wasn't brought up, I appreciate that.
I'm not aware of the 10-9 form, but the implication here is that the court can just issue orders without any statutory backing at that point. And that could potentially open the door for, unlimited judicial power. It's pretty clear that there's, the court has jurisdiction, the court has these options in front of it for sentencing. If it's not the jail sanction, it's a community control sanction, and it appears that the court burned through all of its ability to give a community control sanction by sentencing him to 180 days jail. So I don't think the court should be able to, tell the individual, hey, you can't talk to this person, that person, if there is no community control sanction there to potentially rehabilitate the individual.
Is your view the only way this no contact order could have been issued is if it was a community control sanction?
Yes, unless it was by the individual filing a or a temporary protection order or a civil stalking order. Or one of
Which is
those.
not what happened here, right? There's other avenues for any victim to go to domestic relations or civil or common police court and get protection. That's not what we're talking about here, clearly.
Correct. But I would say, yeah, you would have to be a community control sanction, otherwise the court, on his termination of sanction, I think loses jurisdiction over the individual. They couldn't sentence him to something else. Can't force him to have a job because they've given him all the jail time they can give him. Any other questions?
I don't think so.
Thank you.
Thank you. Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. A copy of the decision will be mailed to you on the day it's released, and also our decisions are on the Ohio Supreme Court website. Thank you again.
Thank you.
Thank you.